Application number 4.
Yes, good morning. Can we get a presentation from the most senior to know who are in the court?
My Lord Judge President and Justices of the Court of Appeal, my name is Francis Gimara. I am assisted by Laston Gulume, and we appear together with Hannington Amol for the respondent in both the application and the appeal. For the appellant and also the applicant in application number 4, 2021, we have Mr. Nicholas Ntarugera, representing the Attorney General of Rwanda, and is also holding brief for the interveners, Mole Rugamba. So that is the representation, my lords, from the bar this morning. And we are ready for both the ruling and in application number 4, 2021, and the judgment in appeal number 10, 2020.
So you mean the Attorney General is making a brief for the interveners?
Very weird.
Nicholas, you are making a brief for the interveners?
Oh, thank you, my Lord Judge President and my lords. Mrs. Mole Rugamba, who is representing the interveners, has requested me to hold her brief because she's not in a condition to appear today. She's sick, and so she has requested me to hold brief for her, my lords, if you so permit. Thank you, my lords.
Yeah, it's okay. It's okay. The regular, but let us proceed. Let us finish this.
So let us proceed. It is not proper, but let us proceed so that at least we have come for the delivery of judgment. Normally it is not proper that the Attorney General make brief for the intervener, but let us proceed. So we 4 of 2021, and we request justice. Yes.
Yeah, he does. Him and you.
Okay, so we start delivering of this ruling.
Thank you, my Lord Judge President. This is the ruling of the court. We start with the introduction. This ruling arises from application number 4 of 2021, filed by the applicant under Rules 4, 94.1, and 95.1 of the East African Court of Justice, EACJ, Rules of Procedure 2019, hereinafter referred to as the rules of this court. The application further arises from appeal number 10 of 2020, hereinafter referred to as the main appeal, now pending before this court, which appeal also arises from the decision of the first instance division, referred herein as the trial court in reference number 10 of 2013. In that reference, the respondent company challenged the takeover and sale of its mall, known as Union Trade Center, hereinafter referred to as the UTC Mall, by the applicant, known as the UTC Mall, by the applicant as being in violation of the treaty for the establishment of the East African Community, hereinafter referred to as the treaty. In the main, the applicant herein challenges the presence and authority of counsel for the respondent to represent the respondent company in the main appeal. At the hearing of the application, the applicant was represented by Mr. Ntwali Emily, Principal State Attorney, and Mr. Nicholas Interagira, Senior State Attorney. The respondent was represented by Mr. Francis Gimara, Senior Counsel, Advocate, and Mr. Huntington Amor, Advocate. Ms. Mole Rigamba, Advocate, represented the interveners. The applicant filed this application by way of notice of motion on the 5th of November 2021. The application is supported by the affidavit of Ntwale Emil, Principal State Attorney and Head of Legal Services in the Ministry of Justice of the Republic of Rwanda, / Office of the Attorney General. The application challenges the capacity of Mr. Francis Gimara, SC, and Mr. Huntington Amor, both advocates herein referred to as the contested lawyers, to be duly appointed counsel representing the respondent and the UTC in this court, in accordance with Rule 19(1) of the rules of this court. The grounds of the application are stated in the notice of motion as follows, and I quote: 1. After the commercial court's appointment of the liquidator as Mr. Rutabingwa at NASE on the 24th May 2021, he filed an affidavit and the commercial court's decision appointing him, notifying this court about the liquidation process for UTC and served the parties to the case. 2. The affidavit signed and served by the liquidator caused doubt and confusion to the applicant as far as the appearance and representation of UTC before the EACJ as envisaged under Rule 19(1). 3. The applicant sought to clear the doubt on who is the legal representative of UTC by writing a letter to the liquidator seeking clarification for the representation and appearance before the EACJ for UTC. 4. On this 4th day of November 2021, Mr. Rutabingwa at NASI, the liquidator, wrote a letter to the Solicitor General of Rwanda denying that UTC in liquidation had appointed Gimara Francis or any other advocate to represent him before the EACJ, thus challenging the capacity of Mr. Gimara and Mr. Huntington Amor as duly appointed advocates to represent UTC before the EACJ. 5. The applicant, therefore, in the interest of justice and for the purpose of clarity on the issue of who is representing the duly appointed advocate to represent UTC before the EACJ in Appeal Number 10 of 2020, who is the advocate to represent UTC before the EACJ Appeal Number 10 of 2020. Since the advocates on record have been denied by the UTC representative, it is therefore very important to get the court's guidance on this issue before the final hearing and determination of the instant appeal. 6. That it is just and equitable in the circumstances that this court consider this application and schedules its hearing for clarity before the pending Appeal Number 10 of 2020 is determined. 7. The applicant chances stands higher risks and to be prejudiced unless this honorable court considers the importance of this application and sets it down for hearing in order to determine on the real controversy about the legally recognized representative of UTC or duly appointed advocate represent it before the EACJ. End of quote. The applicant then made the following prayers, and we quote: 1, for an order that the challenged advocates be put to strict proof for them to produce to the court the power of attorney giving them the mandate to represent UTC as duly appointed advocates in appeal number 10 of 2020. 2, for an order that the hearing of appeal number 10 of 2020 be stayed pending the determination of this application for clarity. 3, for an order that UTC in liquidation is legally represented by the liquidator, Mr. Rutabingwa Atanase, and that he is the only one capable of appointing any advocate to represent UTC before any court of law. End of quote. Proceeding before this court. When the application was first called for hearing on the 8th of November 2021, at the court's regular sitting held at Bujumbura, Burundi, the respondent notified the court that it intended to raise a preliminary objection to the application. At the hearing, the applicant was absent. At that hearing, our clerks and the our court clerks and the intervener, represented by Ms. Molly Regamba, advocate appearing online, suggested that counsel for the applicant could have been experiencing internet problems at their chambers in Kigali, Rwanda, as counsel for the applicant had opted to participate in the proceedings online. The court noted the long history of this dispute in the court, then gave directions for the parties to file written submissions before the next hearing session in February 2021, and be prepared on that date so allocated to argue the application directly. When the application came up for hearing on the 9th of February 2022, both the counsel for the applicant and respondent were in court, and the written submissions for and against the preliminary objection were also on court record. The parties prayed in the interest of time and justice that the objection be determined on the basis of the written submissions and highlights already on court record, which prayer the court granted. We shall now proceed to address the submission of the parties on record and determine the preliminary objection. Submissions by the party. Objection by the respondent. Counsel for the respondent submitted that the application was an abuse of court process and a waste of the court's time. He urged us to take note of the appeal of Honorable Margaret Ziwa versus Secretary General of the East African Community, appeal number 2 of 2017, where this court found, in respect of an argument by the respondent in that appeal, that, and we quote, "It is much ado about nothing. It nonetheless resulted in waste of precious judicial time in both this court and the trial court. The court expressed the hope that in future, red herrings will be spotted early, promptly ignored, and all guns aimed at the real targets." That is paragraphs 61 at pages 30 to 31. End of quote. Counsel further relied on the reasons hereinafter as to why the application as filed was an abuse of court process. Counsel argued that the proceedings in the main appeal had reached an advanced stage and the main appeal had been fixed for hearing under Rule 110(4) of the rules of this court after scheduling. He submitted that the scheduling conference on the 27th May 2021, the record showed clearly that the issue of representation had been canvassed and that the court directed that representation of the parties as had been the case at the trial court, would be maintained for purposes of the main appeal. Counsel further recalled that the issue of representation had also been addressed at the trial court in the Attorney General of the Republic of Rwanda and others, that is the intervener's application number 24 of 2020, in which the applicant was unsuccessful, but after which the applicant did not appeal, instead choosing to circumvent the process by filing the present application. Counsel also argued that following the ruling at the trial court in application number 24 of 2020, the applicant was duly bound not to take any action that may be detrimental and or aggravate the resolution of the dispute before this court as provided for under Article 38(2) of the treaty, which the applicants did not adhere to. Article 38(2) provides, and we quote, where a dispute has been referred to the court, the partner states shall refrain from any action which might be detrimental to the resolution of the dispute or might aggravate the dispute. End of quote. Counsel submitted that the appointment of a liquidator by the courts of the applicant partner state during the pendency of this dispute before this court is tainted with bad faith. Counsel pointed out that in the resolution of this dispute, this court shall have precedence. In this regard, counsel referred us to Article 33(2) of the treaty, which provides, and we quote, decisions of the court on interpretation and application of this treaty shall have precedence over decisions of national courts on a similar matter. End of quote. Counsel argued that this application seeks to irregularly import matters of domestic law to override proceedings in this court, which involve the interpretation and violation of the treaty, which is a preserve of this court. He pointed out that at the appellate level, this court is dealing with the appeal presented in the memorandum of appeal based on the status of the matter as it was at the trial court. Counsel thus prayed that this court finds that the present application is without merit and dismisses it. Reply to the objection by the applicant. Counsel for the applicant objected to the preliminary objection. Counsel argued that since the filing of the reference at the trial court, the applicant had objected to the appearances and representation of counsel for the respondent company. Counsel argued that from the filing of the reference in 2013 at the trial court and subsequently after the appeal to this court, leading to its remittal in 2016 from this court back to the trial court for hearing de novo, the reference, and we quote, was filed by Ruggiero Yabwa Rebet in the names of UTC. See paragraph 5 of the written submissions. However, on admission of the interveners on behalf of the minority shareholders, the interveners objected to Mr. Ruggiero Ayabawa Trebet as the legal representative of the respondent company. Counsel argued that during the examination and cross-examination of Mr. Ruggiero Trebet at the trial court, there was no evidence that the respondent company had itself filed a reference at this court or hired the contested lawyers. However, the trial court ruled differently. Counsel for the applicant submitted that soon thereafter, the minority shareholders filed for liquidation of the respondent company at the commercial court in Rwanda, which application was upheld, and Mr. Rutabingwa Athnese was appointed as the liquidator of the respondent company. This was also notified to all the parties concerned. This state of affairs is what led to the doubt and confusion as to whether the representation of the respondent company complied with Rule 19.1 of the rules of this court. Counsel for the applicant further submitted that it was against this background that the applicant wrote the liquidator to confirm whether the challenged lawyers were representing the respondent company at the ESCJ. The liquidator then, in reply to the said letter on the 4th of November 2021, wrote to the Attorney General of Rwanda, and we quote, denying that UTC in liquidation has not appointed Gimara Francis or any other advocate to represent it before the ESCJ, thus challenging the capacity of Mr. Gimara Francis and Hannington Amor as duly appointed advocates to represent UTC before the ESCJ. See paragraph 24 of the written submissions, end of quote. Counsel argued that this is why the application was filed, and if not addressed, it may affect the court's decision and the process of executing it. Counsel also referred us to Article 103 of Law Number 23/2018 of 29/04 of the Republic of Rwanda on insolvency and bankruptcy, which provides, and we quote, A, the liquidator takes custody and control of the company property. B, the company's officers remain in office but cease to have any powers, functions, or duties other than those required or permitted to be exercised by this law. C, no proceedings, execution, or other legal process may be commenced or continued against the company or its properties except with the liquidator's written consent or with the order of the court. However, the provisions of the preceding paragraph do not affect the right of a secured creditor to take possession of and realize any property in the bankrupt's estate over which that credit has a charge. D, no share of the company may be transferred or other alteration made in the rights or liabilities of any shareholder, and no shareholder may exercise any power under the company's incorporation documents or law governing company. E, the incorporation document of the company may not be altered except that the liquidator may change the company's registered office or full address, end of quote. Counsel argued that by reason of the above law, the liquidation process affects the respondent's legal representation and the case pending before this court. Counsel further argued that if the case proceeded without the liquidator's written consent, then this may in future, and we quote, affect the case, especially during the execution process, end of quote. See paragraph 34 of the written submissions. Counsel submitted that if this court declines to recognize that the respondent company's status has changed, then it would in effect be opposing the decision of the Rwanda Commercial Court to appoint a liquidator. In this regard, he referred us to the head note of the appeal of Mary Araviza and another versus Attorney General of Kenya and the Secretary General of the East African Community, appeal number 3 of 2012, where it was held that, and we quote, discretion is to be exercised judiciously. Court cannot review the decisions of national court. No concurrent jurisdiction between the two ESCJ divisions. point of fact cannot be appealed, whether the first instance division, considering all facts, arrived at its decision. End of quote. Finally, counsel submitted that this application was not filed intending to delay the hearing of appeal number 10 of 2020. Counsel also prayed that the court find that the status of the company had changed and that the contested lawyers do not have the authority to represent the respondent company. Rejoinder by the respondent. Counsel for the respondent in rejoinder largely reiterated their submissions in chief, and where they did so, we see no reason to replicate them. Counsel submitted that the applicant had misread the conclusion and decision in the Mary Arviza case supra, which fortified the respondent's objection in that whereas this court does not review judgments of national courts, it does under Article 35A handle matters of law from the trial court. Furthermore, in this matter, there is no review being undertaken of a decision of a national court. Analysis and determination by the court. We have considered the submissions of the opposing counsel and the authorities supplied to us, for which we are grateful. An application to contest the representation of Mr. Francis Gimara and Huntington Amor as legal counsel for the respondent company following its being put under liquidation by an order of the Commercial Court of Rwanda and the appointment of a liquidator, Mr. Rutabingwa Ananase. Whereas this ruling leads to a preliminary objection raised by the respondent company against the entire motion by the applicant, it appears to us that the motion itself in the process has been substantially argued. The objection revolves around Rule 19.5 of the rules of this court in relation to representation of a company at this court, which provides, and I quote, "A corporation or company may appear by its director, manager, or company secretary, who is duly appointed by a resolution under seal of the corporation, or the company may be represented by an advocate." End of quote. It is the case for the applicant that the contested lawyers do not have the right to represent the respondent company following its liquidation by the minority shareholders through a court order of the Commercial Court of Rwanda, and that there is now the liquidator, Mr. Rutabingwa Ananase, who is in charge of the respondent company and who does not recognize the contested lawyers. The respondent company, on the other hand, objects to the issue of representation after liquidation was resolved by the trial court in their favor, and the decision was not appealed. And therefore, this application is an abuse of court process. It has been argued by the respondent company in the preliminary objection that the trial court had an opportunity to address the issue. We shall recall what the trial court found in application number 24 of 2020. The trial court therein held as follows, and we quote, "It is common ground herein that domestic proceedings in the applicant state were lodged well after this court had issued directions of filing of closing submissions in the reference and after the filing of UTC's written submission. The interveners that initiated the domestic proceedings in question are indeed represented in the reference. It therefore smacks of bad faith that the same interveners could apply for the liquidation of a company that is a party to proceedings in which they emphatically sought to be joined. The central question in the reference is UTC's alleged deprivation of the management, use, and ownership of its mall by the applicant state. For interveners, minority shareholders in the company to seek to circumvent the legal status of the applicant, therein is a clear aversion of due process and disrespectful of the rule of law. As if that were not distasteful enough, they initiated the liquidation proceedings at the tail end of a protracted litigation process in the reference, and after filing and assumed receipt of UTC's written submissions. It is outstanding that they purport to support the present application in the interests of justice. To compound matters, the present applicant, well aware of the dictates of the rule of law that it is obligated to under the treaty, would appear to perpetrate the malefides of the situation. With uttermost respect, we ponder what greater injustice or disregard for due process could there be. Secondly, drawing from the doctrine of equity, she who comes in equity must come with clean hands, end of quote. The maxim bears relief for anyone guilty of improper conduct. Equity further dictates, and we quote, he who seeks equity must do equity, end of quote. Whereby courts will decline to assist any person whose action is grounded in his or her own misconduct towards the other party. Consequently, we take the view that it would not promote the ends of justice, which do not include procedural justice, to grant the present application in the terms sought. It is so held, end of quote. That was the decision of the trial court. Weighing the arguments in this application against the findings in application number 24 of 2020, we are hard pressed to understand the purpose of this application before us. In response to the objection raised by the respondent company, the applicant argued that there is confusion as regards the representation of the respondent company, and therefore this court should provide the necessary clarity. We, on the other hand, wonder if that was the case, then why was the ruling in application number 24 of 2020 not appealed within the meaning of Article 35A of the treaty? The applicants, not having appealed that ruling, are stopped by record to contest it by way of notice of motion, as they seek to do now. The ruling in application number 24 of 2020 is nothing short of an indictment on the conduct of the applicant and the interveners on the subject of liquidation, clearly stating it was an action done in bad faith and it remains on record. To compound that finding through this application is most unwise, an abuse of court process. We are further surprised by the arguments by counsel for the applicant that by this court failing to recognize the liquidation process as ordered by the domestic court, we shall be reviewing the said decision, and that this may cause execution problems in future. With the greatest of respect to that line of argument, it is totally misconceived. First, this court is not reviewing the decision of the Commercial Court of Rwanda. It is addressing a complaint in reference number 10 of 2013. Secondly, as to execution, we recall Article 38 of the treaty, which provides, and we quote, "A partner state shall take without delay the measures required to implement the judgment of the court," end of quotation. So there can be no question of failure to implement the judgment of this court without further violation of the treaty. Fortunately, partner states have complied with this provision without need for further enforcement. We also need to point out that the import and legal question of this motion in substance reflects the ground in the main appeal, especially grounds 4 and 5, which state, and we quote, that the learned justices of the first instance division erred in law by declaring that the appellant's objection to UTC's local standard is inadmissible with reference to Article 31 of the treaty, ignoring the fact that there is no board or shareholders resolution allowing UTC to file a case at the ESCJ. In this respect, the court also ignored the fact that only one shareholder took the initiative to file the reference on behalf of UTC without the informed approval and consent of the shareholders. The lawyers who purported to indicate that they represented UTC only represented an individual shareholder who unilaterally instructed the lawyers, and UTC was not a litigant in the reference. That the Honorable Justices of the First Instance Division erred in law by declaring that UTC was properly represented before it by an advocate who was not appointed by UTC to the court. This motion is also indicative of a fishing exercise by raising the same argument clothed differently multiple times, which is further evidence of abuse of court process. Furthermore, if the applicant seeks to fault the challenged lawyers, then the onus falls entirely on them to prove the allegation and not on the respondent company to affirm a negative proposition. Counsel for the applicant insisted that the contested lawyers had to provide a power of attorney from the respondent company to prove that they had been instructed by the said company. It is not clear on what legal authority or basis counsel made this submission. He did not in any event provide it. For purposes of the reference, Rule 25(4) of the Rules of this Court provides, and we shall quote, with reference, where the reference is made by a body corporate, the statement of reference shall be accompanied by documentary evidence of the existence in law of that body, end quote. In this matter, from the record, there is evidence that the respondent company, being a body corporate in Rwanda, and which position is not contested by the applicant, but so is not contested by the applicant, which position, I beg your pardon, which position is not contested by the applicant. So this provision was complied with.
Thank you. Before we take leave of this matter, even though this is not the main thrust of the application, we need to debunk the argument of that the order of the liquidation by the Commercial Court of Rwanda would mean that the liquidator would somehow take over control of the proceedings already commenced in this court. With the greatest of respect, that cannot be the correct legal position with regard to the law relating to insolvency. Insolvency is a process that is directed at protecting a company from its creditor, but not its debtors. In this matter, attached to the affidavit of Mr. Ntwari Emile, the principal state attorney, is attached the judgment of the Commercial Court of Rwanda, number RC OM 013004/2020/TC, both in the English and the Rwanda languages. Unfortunately, Mr. Ntwari Emile, for purpose of Article 46 of the treaty and the Rule 11, Sub-Rule 7 of the rules of this court, neither indicated which of the two versions of the judgment is in the original, nor stated which of them is the certified translation. So we shall not make a reference to the said judgment. What we shall do is to make a comment on the insolvency law. In paragraph 6 of the affidavit in support of the motion, Mr. Ntwari Emile makes mention of clause 3 of Article 103 of the law, number 23/2018, of 29 April 2018 on insolvency and bankruptcy, and avers that by reason of the appointment of Mr. Lutabingo Athanase as a liquidator of the respondent company, he alone can be the legal representative of UTC. Counsel for the applicant also argued that the main appeal cannot proceed without the liquidator's written consent. The said clause of the law provides as follows, and we quote, "No proceedings, execution, or other legal process may be commenced or continued against the company or its property except with the liquidator's written consent." End of quote. The key words here are against the company. This is very much in line with the universally known principles of the law of insolvency, where the insolvency process protects the company against a rush by its creditors. It must be recalled that the reference number 10 of 2013 was not instituted against UTC by the current applicant as a creditor, but rather by the UTC against the applicant, because at the end of the day, if the claim by UTC is vindicated at law for the alleged unlawful sale of the UTC mall, then the applicant would become the debtor and not the creditor of UTC. On the contrary, therefore, it is the actions by the applicant and its agencies like the Rwanda Revenue Authority, RRA, as the creditors against UTC, which would be caught by the cited law, and no legal process by them could be commenced or continued against UTC without the consent of the liquidator. So whether at the international or domestic law, these provisions would not be applicable to the main appeal. In this regard, we find that the decision of Mary Arivisa case supra is not applicable here, and in any event, the applicant only cited the head note and not the judgment itself, which is irregular. This application, among other provisions, is premised on Rule 4 of the rules of this court, which provide, and we quote, "Nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the court to make such orders or give such directions as may be necessary for the ends of justice or to prevent abuse of the process of the court." End of quote. This rule is a double-edged sword in the sense that, on the one hand, it allows for the ends of justice to be met, which is what the applicant seeks to achieve, while on the other hand, it also seeks to prevent the abuse of court process, which is what the respondent company wants this court to invoke. All in all, from our findings above, it is clear that this application, for the reasons given above, is an abuse of court process and is therefore not sustainable. We therefore uphold the preliminary objection. As to costs, Rule 127 of the rules of this court provide that costs follow the event unless the court, for good reason, otherwise orders. In this matter, we award costs to the successful party. And finally, the final result. The notice of motion dated and lodged in this court on the 5th November 2021 is struck out with the costs awarded to the respondent, and it is so ordered. Dated and delivered at Arusha, this 30th of August 2022.
Most obliged, my lords.
Much obliged, my lords.
Most obliged.
Yes.
Most obliged, my lords.
We call it finish. Yeah. Yes.
Cabinet Relations, Appeal number 10 of 2020, the Tribunal of the Republic of Rwanda, the Civilian Trade Center in Athens.
Yeah, I think for the interest of the court, let us get also the introduction from the parties, from the interest of court. Mr. Gimara.
My Lord Judge President, my Lords, the Justices of Court of Appeal, for the record regarding Appeal number 10/2020, for the respondent, Francis Gimara, assisted by Laston Gulume, appearing together with Hannington Amol. We act for the respondent. For the appellant, my lords, my learned brother Nicholas Ntarugera represents the Attorney General of Rwanda in the appeal, and he continues to hold brief for the interveners, Mole Rugamba, as well in this appeal, number 10 of 20. My lords, we are ready for the judgment in appeal number 10/2020.
Yeah, thank you very much. But Mr. Gimara, you know you are in court. You talk a city, you never rise. You should know that, Mr. Gimara, we are in court. You can see that Nicholas rises, but
my lord, I rose.
Your brothers
I
just sit.
right. I have to move my chair behind. I think I did do so, my lord. That's the last time I have complied. Even in these proceedings, I can confirm to you I've been rising at every occasion where it's so required.
Okay, no, you know, that is a good practice because the Attorney General is rising, but you others, you are just sitting as if nothing. You are out of court. We are in court, even if we are online. We are on court. So I think it's better that we follow these good practices. So now we are delivered this judgment in appeal number 10 of 2020, and we request Justice Anita to, yeah.
Here is the judgment of the court. Introduction. This appeal and cross appeal arises from the decision of the first instance division of this court, and after referred to as the trial court, in reference number 13 of 2013, dated 26 November 2020. The appellant, who was the respondent at the trial court, is the Attorney General for the Republic of Rwanda, hereinafter referred to as the appellant. The respondent and cross-appellant, which was the claimant at the trial court, is a company incorporated on 20th May 1997 under the laws of the Republic of Rwanda, hereinafter referred to as the respondent. Together with these parties are 3 interveners who are described as minority shareholders in the respondent company who intervened in favor of the appellant here and at the trial court. At the trial court, judgment was rendered in favor of the respondent, whereby the appellant's action in taking over the respondent's mall and subsequently set it off were declared illegal and in contravention of Articles 53G, 6D, 7(1)A and 2, and 8(1)A and C of the Treaty for the Establishment of the East African Community, hereinafter referred as to the treaty. At the appeal, the appellant was represented by Emile Ntwari and Mr. Nicholas Ntarugera, Senior State Attorney, Minister of Justice of the Republic of Rwanda. The respondent was represented by Mr. Francis Gimara, Senior Counsel of ALP Advocates of Kampala, Uganda, and Mr. Hannington Amol of ALP Advocates of Nairobi, Kenya. The interveners were represented by Ms. Mole Rugamba of MSRA Associate Kigali, Rwanda. backgrounds. The fact of this dispute, as is the history of the case in this court, is quite long and convoluted. Briefly, the facts start with the filing of the reference at the trial court in the reference number 10 of 2013, which, when came on appeal to this court in appeal number 10 of 2015. This court on appeal then ordered that the original reference at the trial court be tried de novo, which was done, and the decision thereof, dated on 26th November 2020, is now the subject of this present appeal. The fact of this dispute can be gleaned from the judgment of the trial court, and pleadings on record can be summarized as hereinafter. The respondent was incorporated as a limited liability company under the laws of the Republic of Rwanda in May 1997. By its certificate of domestic company registration, the respondent was incorporated generally to engage in real estate, but especially to run a commercial mall known as Union Trade Center, hereinafter referred to as the UTC Mall in Kigali, Rwanda. Its shareholders comprise Mr. Tribert Rujugiro with 1,933 shares, Mr. Theonest Mutambuka with 41 shares, Succession Makuza Desire with 3 shares, and Succession Nkurunziza Gerard with 20 shares. The business of the respondent progressed well until or about the 1st August 2013, when the office of the committee, else in the record sometimes referred as the commission in charge of unclaimed property in Nyarugenge, hereinafter referred as the committee in charge of the unclaimed property, established under law number 28/2024, ordered the respondent to submit to it a list of documentation as to its operation, and in particular the UTC Mall, which was done. It would appear that thereafter a series of meetings, the main one being the 27th September 2013, ensured between the respondent and the committee in the charge of unclaimed property, with the aim of understanding the reason for the intervention of the committee in charge of unclaimed property into the affairs of the respondent company. On or about the 2nd October 2013, the committee in charge of unclaimed property notified the tenant of the UTC Mall that the said mall had been placed under its control, and that further rentals should be paid by them into a designated account at MS Fina Bank in the names of the said committee, effective from 1st October 2013. The tenant at the UTC Mall complied with this directive. Meanwhile, the respondent instructed its lawyers, who by a letter dated 2nd October 2013 demanded that the above directive be rescinded, but this came to nothing, as the letter was not replied to. While this alleged takeover was progressing, the situation surrounding the mall escalated when the Rwanda Revenue Authority, hereinafter referred to as the area, says it on assessment of unpaid tax of United States dollars $1,100,000, and eventually had the UTC Mall auctioned and sold to a third party, MS Kigali Investment Company, at $6,877,150,000. at 6,877,150, approximately 1,100,000 USD. It is a case of the respondent that by reason of the actions of these institutions, the government of Rwanda incurred state's responsibility at regional and international in violating its own laws, and in addition contravening Articles 53G, 6D, 71A and 2, 81A and B and C of the treaty. On the other hand, for the appellant, it is contended that it did not violate any of its law or provision of the treaty as alleged, and that the dispute filed in this court is misconceived and devoid of merit. It is further the position of the appellant that this court lacks jurisdictions to adjudicate of the matter. It is not worth before we trace the proceeding of this dispute in court to point out that while the matter was still in the courts, the interveners herein applied for the liquidation of the respondent company in the domestic court of Rwanda, and that a court order of liquidation was secured. It is therefore the contention of the interveners that only the liquidator has power to sue on behalf of the respondent and not the shareholders.
Thank you, Judge President. We continue with the reading of the judgment. The first reference. For ease of recollection, we shall briefly restate how this dispute first came to this court, as summarized from the decisions of this court, the facts of which we take judicial notice. The appellant initially on the 22nd November 2013 filed reference number 10 of 2013 at the trial court. The respondent, then as applicant, alleged that on 2nd October 2013, the committee in charge of unclaimed property informed tenants in the UTC Mall that effective 1st October 2013, they were required to redirect their rental payments to the said committee. The respondent contended that the actions of the committee in charge of unclaimed property in so doing contravened Articles 5.3, 6D, 71A and 2 and 8.1 of the treaty. The appellant at the trial court raised two preliminary points of law. First, the jurisdiction of this court to entertain a reference premised on actions of an entity that was neither a partner state nor institution of the EAC, and secondly, on the limitation of time within which a reference may be brought before this court. The trial court, in its decision dated 27 November 2014, noted that the issues raised in the reference were of great importance to the East African community and partner states, and that the court had not previously adjudicated this type of case before. The court found that it had jurisdiction and that state's responsibility for the alleged misconduct of the committee in charge of unclaimed property has been established. On jurisdiction regarding a time limitation, the trial court found that the reference was not time-barred and that the respondent applicant and got to know of the committee in charge of unclaimed property assumption of the UTC Mall's management on 2nd October 2013 by reason of a letter to that effect, and since the reference was filed on 22nd November 2013, the reference was filed within the 2-month time limitation prescribed by Article 32 of the treaty. As to the course of action, the trial court found that the present respondent had not proved that the appellant had contravened Rwanda's internal laws, and furthermore, that Furthermore, the trial court did not have jurisdiction to determine that issue. It therefore found that there was no evidence that the impugned actions violated the principles as enshrined in Article 6 D and 7.2 of the treaty. Secondly, although Law Number 28 of 2004, under which the acts complained of were undertaken, may be deemed a measure for purposes of Article 8.1c and would therefore open to scrutiny by this court, that law was not in issue in the present reference. Both parties then appealed this decision of the trial court to this court by way of appeal and cross appeal in appeal number 1 of 2015. This court in civil appeal number 1 of 2015 in its decision of 20th November 2015 found that the pleadings and hearing of the appealed reference was fraught with procedural irregularities because there was no evidence that had been adduced on record, and this had occasioned miscarriage of justice. This court then remitted the reference back to the trial court for hearing de novo with directions that the parties had been afforded an opportunity to present with the directions that the parties be afforded an opportunity to present evidence to support their respective cases. Trial of the reference de novo. On remitting the reference to the trial court for a hearing de novo, the respondent as applicant filed an amended reference. When the said reference came up for hearing on 6 September 2016, the respondent sought leave and was allowed to amend its reference. Consequently, on 4 November 2016, an amended reference, hereinafter referred to as the first amended reference, was filed at the trial court. On 15 November 2017, when the first amended reference came up for a scheduling, it transpired that the UTC mall, the subject matter of the reference, had recently been auctioned off by the RRA on account of its alleged failure to pay taxes due to the government of the Republic of Rwanda. The respondent then sought leave of the court to amend the first amended reference to introduce the fact of auction of the UTC mall. Counsel for the appellant, on his part, considered on record that it was the respondent's right to amend pleadings and that he would neither object nor support the application, and it was within the powers of the court to decide the matter. The trial court ultimately granted the respondent leave to amend the first amended reference, and the second amended reference was then filed in court on 13th December 2017. In addition, it is important to point out at this stage that by reason of a ruling in application number 4 of 2017, the interveners to this reference were admitted to the case and directed to file a statement of intervention in the matter. On 8th January 2018, the appellant filed application number 1 of 2018, seeking to strike out or expunge the second amended reference on the grounds that the same was an abuse of the process of the court in that, 1, it had introduced a new course of action contrary to the principles governing amendment of pleadings. 2, it prejudiced the appellant as there was a matter pending for determination in the original reference on both a preliminary objection to the effect that the same was time-barred and the issue of the locus standi of the respondent which had been raised by the interveners, and 3, the amendments contravened this court's order on 15th November 2015 to the effect that the reference be tried de novo. The trial court, in an elaborate ruling delivered on 29th March 2018, found that the appellate court's order for a de novo hearing did not preclude amendments to the pleadings already on record. Furthermore, the apparent preliminary objection and issues of locus standi of the respondent were not prejudiced by the amendment. They did not raise a new cause of action. The trial court found that the Second Amendment reference would neither prejudice nor delay the fair trial of reference number 10 of 2013, but rather the amendment clarified on the real issues in controversy between the parties. In the final result, the trial court disallowed the application to strike out the second amended reference with no orders as to costs. On further appeal to this court on the above decision of the trial court, the parties raised the issues at scheduling. 1. Whether the trial court erred in law by disallowing the application to strike out the second amended reference, and 2. What reliefs are the parties entitled to? On 29 May 2019, this court rendered a ruling and found the apparent and failed to establish any error of law or procedure on the part of the trial court in allowing the second amended reference. This court then decided and ordered the appeal be dismissed with cost to the respondent. With the application disposed of, the trial court was now free to proceed with the second reference. Trial and hearing of the second reference. Issues for determination. In preparation of the trial, the parties agreed on the following issues. 1. Whether the reference is time-bound and should be struck off the record. 2. Whether the applicant has locus standi. 3. Whether the respondent was properly sued before this honorable court. 4. Whether the respondent's actions of taking over the applicant's UTC MAL and consequently auctioning it are inconsistent with and or in contravention of Articles 5.3G, 6D, 7.1A, and 8.1A and C of the treaty. And lastly, what are the remedies available to the parties? Keys for and decision on the statement by the interveners. Before we recall the decision of the trial court on the issues, it is important that we address the case for and decision of the court on the statement of the interveners in this matter. The interveners filed submissions dated 31st August 2020, in which they raised issues of whether the reference was time-barred, the applicant's locus standi, and whether the respondent has been rightly sued. The trial court found that Article 40 of the treaty restricts an intervener's role in a reference to matters of fact or evidence and not those of law. The trial court, however, found that the intervener's submission sought to address both questions of law and fact. The trial court therefore decided that it would not take into account the intervener's submissions as to the law of the dispute. The trial court further found that the interveners had filed affidavits alongside their written submissions. This, the trial court found, offended the rules of natural justice because the said affidavits were filed at the time of the closing submissions when the opposite parties would not have an opportunity to respond to them. The court then expurged the offending affidavits from the record and held that it would only consider what remained of the intervener's submissions as appropriate. The trial court, in respect of issue number 1, resolved the issue in the negative and found that second amended reference was filed within the 2-month period prescribed by Article 32 of the treaty. In respect to issue number 2, the court found in the affirmative that the applicant and locus standi. In respect of issue number 3, the court found in the affirmative that the reference was properly instituted against the respondent. In respect to issue number 4, the court found in the affirmative that the respondent's actions of taking over the UTC MAL and subsequently auctioning it off to be inconsistent with Articles 5.3G, 6D, 7.1A, and 1A and 2, and 8.1A and C of the treaty. However, the court found that there was no violation of Article 8B of the treaty. In the final resort, the trial court found and determined the reference in the following terms. Quote, a declaration is hereby issued that the respondent's actions of taking over the UTC mall and subsequently selling it off are illegal and contravene Articles 53G, 6D, 71A and 2 and 81A and C of the treaty. 2, the respondent is directed to furnish the applicant with accountability for the rental and sale proceeds realized from the UTC mall between 1st October 2013 to 27th September 2017. 3, compensation in general damages is awarded in the sum of United States dollars 500,000. And 4, simple interest at 6% per annum is awarded against the compensation designated above from the date of this judgment until payment in full and costs are awarded to the applicant. Close of quotes. Being dissatisfied with the decision of the trial court, the appellant herein lodged in this court and served upon the respondent a notice of appeal dated 30th November 2020. The appeal to the appellate division. The memorandum of appeal. The appellant filed an appeal with the following grounds in its memorandum of appeal. 1, that the learned judges of the first instance division erred in law wittingly in dispensing a judgment against the appellant by allowing reference number 10 of 2013 and all the orders sought by the respondents thereto with costs. 2, the Honorable Justice of the First Instance Division erred in law by issuing a judgment that was biased against the appellant. 3, that the Honorable Justice of the First Instance Division erred in law by issuing a declaration against the appellant, deliberately declaring that the reference was filed on time without considering the real date of 21st July 2010 when the cause of action arose, thus mixing up the cause of action to be the letter dated 2nd October 2013, yet it was implementing decisions taken on 29th July 2013. 4, that the learned justice of the First Instance Division erred in law by declaring that the appellant's objection to UTC's local standard is inadmissible with the reference to Article 31 of the treaty, ignoring the fact that there is no board or shareholders resolution allowing UTC to file a case at the East African Court of Justice. In this respect, the court also ignored the fact that only one shareholder took the initiative to file the reference on behalf of UTC without the informed approval and consent of other shareholders. The lawyers who purportedly indicated that they represented UTC only represented an individual shareholder who unilaterally instructed the lawyers. UTC was not a litigant in the reference. 5, that the Honorable Justice of the First Instance Division erred in law by declaring that UTC was properly represented before it by an advocate who was not duly appointed by UTC. 6, that the Honorable Justice of the First Instance Division erred in law by rejecting the intervener's statement of intervention and their evidence, yet it was the same court that admitted them on the record to be parties to the matter. The court denied them their role to support the appellant's position in the case by refusing them an opportunity to file an intervener's statement and evidence. 7, that the Honorable Justices of the First Instance Division erred in law by issuing a judgment against the appellant deliberately that the takeover and managing of the UTC mall by the commission in charge of the abandoned property and the auctioning of the same mall by the Rwanda Revenue Authority was illegal and contravenes the EAC Treaty Articles 53, Articles 53, 6D, 7.1 and 2, and 8.1A and C, a decision that contravened Rwanda's internal laws, yet this Honorable Court has no jurisdiction to determine on such issues concerning the applicability of national laws. Yet the said actions complied with domestic law as well as with the cited treaty provisions. 8. That the Honorable Justices of the First Instance Division add in law by accepting and considering the respondent brackets applicant in reference number 4 of 2010 written submissions together with authorities found on 1st August 2020, which were found in violation of Rule 11.2 and 3 of the rules of this Honorable Court 2019. The same 40 documents which are improperly on the record were based on by the Honorable Justices to wrongly decide the case in favor of the respondent. 9. That the Honorable Justices of the First Instance Division add in law by stretching their discretionary powers multiple times, thus violating rules 11.2 and 3 of the rules of this Honorable Court. And then 10. That the Honorable Justices of the First Instance Division add in law by issuing a declaration awarding damages with interest to the respondent. The appellant further print that this court grant the following remedies. 1. A declaration that UTC was neither a litigant nor legally represented before the ESCJ. For declaration that on the 22nd, for declaration that on the date of 22nd November 2010, the purported UTC that found reference number 10 of 2013 lacked local standard to file the reference, that the reference was not properly introduced before the Honorable Court. One order that reference number 10 of 2013 was filed out of time. For an order that the actions of taking over the mall and auctioning it was in accordance with Rwanda's laws and do not in any way contravene Articles 5, 3, 6D, 7.1 and 2, and 8.1A and C of the treaty. For declaration that the written submissions and the authorities thereto found by the purported UTC were wrongly found and admitted on the record, that they could not be based on for any determination in the reference by the court. For a declaration that the interveners were denied an opportunity to support the appellant's position through their statement of intervention and evidence. 7. To reverse the decision of the First Instance Division entirely. 8. For a declaration that each party bears its costs. And 9. For a declaration that this Honorable Court is not vested with powers to interpret the applicability of national laws and thus does not fall under its jurisdiction. The cross appeal. The respondent cross apparent company
There's feedback.
The respondent The respondent cross apparent company also partly dissatisfied with the decision of the trial court filed a cross appeal, wherein it prayed that the above named decision ought to be varied or reversed on the grounds hereinafter, namely, 1, that the trial court had in law when it omitted to make clear orders for the remittal of rental proceeds realized from the UTC mall between 1st October 2013 27 September 2017 by the appellant. 2, that the trial court had in law when it omitted to make an order for restitution of the UTC mall on finding that it was illegally seized and sold by the appellant. 3, That in the alternative to ground 2, the trial court erred in law when it omitted to make an order for compensation for the value of the UTC mall on finding that it was illegally seized and sold by the appellant. The respondent respondent further prayed for orders that 1, an order that the appellant remit to the respondent the rental proceeds derived from the UTC mall between 1st October 2013 to 27th September 2017. 2, an order for the restitution of the UTC mall against the appellant, and in the alternative, an order for compensation for the value of the UTC mall against the appellant, and 3, costs of the cross appeal.
Yes, you can. It's okay.
Thank you, Judge President. The scheduling conference for the appeal and cross appeal. The appeal and cross appeal came up for scheduling on the 27th May 2021. At the scheduling conference, the appellants sought leave of the court to amend the grounds of appeal by merging some grounds while rephrasing others, which leave was granted. The adjusted grounds are as follows. 1, the Honorable Justices of the First Instance Division erred in law when they acted with bias by allowing the filing of several references that differed in substance with the original reference in number 10 of 2013, contrary to the ruling of the Appellate Division and the rules of procedure of the court, thereby arriving at a wrong decision. 2, the Honorable Justices of the First Instance Division erred in law when they stretched their discretionary powers by allowing the respondent to combine 2 causes of action arising at different times into one cause of action, contrary to the court rules, thereby exceeding the powers granted by the provisions of the treaty and the rules of the court. 3, the Honorable Justices of the First Instance Division erred in law by holding that reference number 10 of 2013 was properly before the court, yet there was no lawful authority allowing the respondent to file the reference before the East African Court of Justice. 4, the Honorable Justices of the First Instance Division erred in law by rejecting the intervener's statement of intervention and their accompanying affidavit evidence, yet it was the same court that admitted them on record as interveners in the matter. 5, the Honorable Justices of the First Instance Division erred in law when, without the requisite jurisdiction, entertained reference number 10 of 2013, which related to matters reserved for domestic Rwandan institutions, thereby arriving at a wrong decision. The parties also agreed to the following grounds of the cross appeal, bringing the total of the grounds in issue to 8. 6, that a trial court erred in law when it omitted to make clear order for the remittal of rental proceeds realized from the UTC mall between 1st October 2013 to 2nd September 2017 by the appellant. 7, that the trial court erred in law when it omitted to make an order for the restitution of the UTC mall on finding that it was illegally seized and sold by the appellant. Number 8, that in the alternative to ground number 2, the trial court erred in law when it omitted to make an order for compensation for the value of the UTC mall on finding that it was illegally seized and sold by the appellant. Having amended and adjusted the grounds of appeal, the appellant further adjusted the prayers of the appeal as follows. A, for a declaration that the First Instance Division had no jurisdiction to entertain reference number 10 of 2013. B, for a declaration that reference number 10 of 2013 was improperly filed before the East African Court of Justice. C, for an order reversing the entire decision of the First Instance Division. D, for an order dismissing the cross appeal. E, for an order that each party pays their own costs. F, for any other order that the court may deem fit in the circumstances. The respondent cross-appellants retain their prayers as filed in this court. The parties then also agreed to the following issues for trial. Issue number 1, whether the appeal is filed in accordance with the rules of this court. Number 2, whether the trial court erred in law by holding that the filing of the reference was not time-barred. 3, whether the trial court erred in law in holding that Rujugiro Tribet, who sued on behalf of the respondent, had locus standi to institute the suit, that is the reference. 4, whether the trial court erred in holding that the appellant's action of taking over the respondent's UTC mall and its subsequent auctioning was inconsistent with Articles 53G, 6D, 71A, 81A, and B, and C of the Treaty for the Establishment of the East African Community. Number 5, whether the trial court erred in law when it omitted to make further orders beyond requiring the appellant to furnish the respondent with accounts for rental and sale proceeds realized from the UTC mall between the 1st October 2013 and 27 September 2017 by the appellant. 6, whether the trial court erred in law when it omitted to make an order for restitution of the UTC mall or in the alternative full compensation for the value of the UTC mall on finding that it was illegally seized and sold by the appellant. 7, what are the remedies available to the parties? The interveners were also allowed to file a statement on appeal as the decision of the trial court had a bearing on their participation. However, before we proceed to resolve the issues as agreed by the parties and the court at the scheduling conference, it is necessary to point out that when we reviewed the submissions, the appellant wrote at page 18 of the written submissions that they had further amended issue number 3 to read as follows, I quote, whether the trial court erred in holding that the respondent had locus standi and that Tribet Rujugiro had lawful and or proper authorization to institute the suit, other than whether the trial court erred in law in holding that Rujugiro Tribet, who sued on behalf of the respondent, had locus standi to institute the reference. Counsel argued that since the trial court had found that the appellant had mixed up Rujugiro's rights or powers to initiate the proceedings with the principle of locus standi, it should be understood that the appellant's intended argument at all times was that Tribet Rujugiro had no authority to initiate proceedings with the ESCJ. Counsel for the appellant at page 19 of the written submissions further submitted that he had found it necessary to add another issue which in his opinion would better elucidate the allegation of bias by the trial court as stated in the agreed issue number 1. The new issue was crafted as follows, I quote, whether the Honorable Justices of the First Instance Division erred in law and procedure by allowing the filing of several amendments to the reference that substantially changed the original reference filed by the respondent, thus arriving at a biased, wrong decision against the appellant, end of quote. We wish to make it categorically clear that under Rule 1110, Rule 110, Sub 1 or Rule 110 Sub 1A of the rules of this court, The primary purpose of holding a scheduling conference is to ascertain the points of agreement and disagreement in the appeal. Furthermore, under Rule 110.2, the parties should, as far as it is practicable, jointly agree on the matters required at the scheduling conference and file them in court. Where under Rule 110 sub 3 of the rules of this court, the parties cannot agree on these matters, then each party may file and serve its own memorandum of the issues. However, Rule 110.4 of the rules of this court then provides as follows. I quote, after the scheduling conference, if the matter is to proceed to hearing, the court shall fix the date for commencement of the hearing. So after the scheduling conference, the matter then proceeds for hearing. In this matter, however, after guidance to the parties by the court and the scheduling conference, issues were framed and the court had a date for hearing. Clearly, the appellant unilaterally continued to modify the issues framed at the scheduling conference without the express leave of the court and or agreement of the respondents. This was highly irregular and unacceptable. Ordinarily, this court would have struck out all the matters that were introduced into the hearing after the scheduling conference without the leave of the court. Indeed, counsel for the respondent declined to address these new and additional matters. However, after careful consideration of the said adjusted and newly added issue by the appellant, we are of the view that some of the said new matters are just arguments or some issues under the issues already agreed to at the scheduling conference. That notwithstanding, as a result of these changes, the written submissions of the parties are not fully aligned and synchronized. We shall, as a result, have to align and synchronize. We shall have to align and synchronize the arguments in the written submissions of the parties ourselves. For now, we simply caution against any variation to what has been agreed to at the scheduling conference and after the matter has been fixed for hearing. Issue number 1, whether the appeal is filed in accordance with the rules of this court. The appellant's submissions. Counsel for the appellant with regard to this issue argued very briefly and submitted that this appeal is properly before the appellate division in accordance with the treaty and the court's rules of procedure. The respondent's submissions. Counsel for the respondent opposed the appeal. Counsel argued that the appeal was not properly before the court because it did not satisfy the mandatory conditions of Article 35A of the treaty and Rule 86 of the rules of this court, which set conditions precedent which have to be met. He relied on the decision of this court in Simon Peter Ochieng and another versus the Attorney General of Uganda, Appeal number 4 of 2015, for the proposition that the condition sine qua non under Article 35A and Rule 86 of the rules of this court requires that the appellant first establish errors either on points of law, lack of jurisdiction, or procedural irregularity that the trial court committed. He further submitted that on the authority of Simon Peter Ochieng Supra, that the onus to prove those conditions lay with the appellant, which they have failed to discharge. Counsel for the respondent further argued that the appellant had failed to comply with Rule 99(1) of the rules of this court to effect service of the memorandum of appeal within 7 days after lodging the same. He submitted that the appellant lodged their memorandum of appeal on the 30th December 2020 and served the respondent lawyers on the 12th January 2021 outside the 7 days period prescribed under Rule 99(1) of the rules of this court. He also submitted that the appellant had not furnished any reasons for failing to comply with the mandatory requirements in Rule 99(1) of the rules of this court. Counsel for the respondent, relying on our decision in Media Council of Tanzania and others, versus the Attorney General of the United Republic of Tanzania, application number 5 of 2019, argued that where a party has failed to take a step within the required time under the rules of the court, then the best remedy was to apply to the court to extend the said time, failing which a notice of appeal would be struck out. The appellant's submissions in rejoinder. Counsel for the appellant, in their submissions in rejoinder, submitted that the appeal met the required conditions precedent under the treaty and rules of this court. He submitted that the grounds of procedural irregularity and want of jurisdiction clearly come out in ground number 2, where the appellant impugns the trial judgment as biased. He further referred us to ground 3 that impugns the judgment for entertaining the reference filed out of time. Ground 4 that impugns the judgment for entertaining a reference that was improperly before the court. Ground 7 that impugns the court's judgment for determining matter that was outside its jurisdiction, as these were reserved for domestic laws and institutions. The determination of the court. We have considered the rival submissions of the parties and the authorities provided to us, for which we are grateful. To launch an appeal in this court, one has to meet the requirements in Article 35A of the treaty. An appeal can be made from any judgment or order on the following: A, points of law; B, grounds of lack of jurisdiction; C, procedural irregularity. These provisions are echoed in Rules 86 of the rules of this court, 2019, as now amended. This court also gave the parameters against which an appeal would be measured to find if it meets the required tests in Article 35A in the matter of Simon Peter Ochieng, Supra, where the court held that an appeal brought before this court outside the scope created by the above relevant provisions is certainly without merit and is untenable. The court went further to hold that, I quote, under Article 35A of the treaty above quoted, a party alleging an error of law, a ground of lack of jurisdiction, or a procedural irregularity must advance argument in support of his allegations. Litigants should bear in mind that this court is not tasked to undertake a rehearing de novo of questions of fact and law examined by the first instance division. The right to appeal to the appellate division is restricted to the extent that the appeal falls within the scope of Article 35A. This court further held that it is not at the appellate division where the appellant establishes facts as if this division is exercising original jurisdiction in this matter. Reproduction of facts presented in trial court does not help the appellants to make tenable an appeal before this division. Finally, this court held that the fact that the losing party does not like the verdict of the trial court is not enough to sustain an appeal, since the appeal to the appellate division of this court is restricted, as we discussed above. This court also made it clear that the burden to establish the alleged error of the trial court lies on the party alleging that error. The said party must explain what the alleged error is and how it led to a miscarriage of justice. We have looked at the grounds of appeal and are satisfied that they point to alleged error and how the error is aligned with Articles 35A and Rule 86 of the rules of this court. As to the issue of time of service of the memorandum of appeal, We note that this objection is being raised late at the time of submissions and at best can be viewed as an afterthought for which we are not able to entertain. We therefore on this issue with the submission. In this regard, agree with the submissions of counsel for the appellant. We therefore answer this ground in the affirmative. Issue number 2, whether the trial court erred in law by holding that the filing of the reference was not time-barred. The appellant's submissions. Counsel for the appellant submitted that it is the appellant's case that the cause of action in this matter arose on the 27th September 2013. However, the trial court preferred to take an alternative date of 2nd October 2013, which is the date of the letter which instructed the tenants of UTC Mall to redirect their rent into an account in FINA Bank in the names of the committee. Counsel argued that this conclusion by the court was reached in error, since the facts and evidence abundantly show that both the respondent and the court were aware that the date of the cause of action was not the 2nd October 2013. Counsel further submitted that in determining the cause of action, the trial court mixed up two events, namely the takeover of the mall and the enforcement actions by the RRA. Counsel argued that lumping together the two events in the second amended reference to compute time was a grave error that occasioned injustice against the appellant. Counsel argued that the second amendment of the reference, in order to include actions of the RRA, was made in disregard for the rules of procedure of this court by lumping in the same reference new causes of action in the matter without regard to the law. The respondent's submissions. The respondent opposed this issue. Counsel for the respondent argued that the trial court was alive to how time should be computed for purposes of Article 32 of the treaty. He argued that the trial court followed the guidance of this court in the matter of the Attorney General of the Republic of Uganda and another, versus Omar Awaz and 6 others, appeal number 2 of 2012, where it was held at paragraph 60 thereof that in computing time, the starting date of an act complained of under Article 32 is not the day the act ends, but the day it is first effective. Counsel argued that this was the same position taken by the trial court in the earlier matter of Grand Lax Supplier, SARL, and others, as Attorney General of the Republic of Burundi, reference number 6 of 2016. Counsel contended that for the reasons stated above, the trial court was alive to the evidence that the decision to take over the management of the respondent's mall was effected on 2nd October 2013. The submissions of the interveners. The interveners supported the submissions by the appellant. Counsel for the interveners submitted that the trial court tried to justify and differentiate an action from a decision by finding that the meeting of 29th July 2013, evidenced by minutes of a meeting on record, was a decision, while the takeover of the UTC Mall, evidenced through a letter of 2nd October, was an action. However, counsel argued that this differentiation still did not preclude the fact that the first cause of action was crystallized by the meeting of 29th July 2013, because all the subsequent actions were based on the decisions taken at this meeting. Counsel for the interveners further argued that if the court had admitted the interveners' evidence in the expunged affidavits as required by law, the court would have realized that in the meeting of 29th August 2013, Mr. Rujugiro was represented. He cannot therefore say that he got to know about the takeover through a tenant, yet he was represented in the previous meetings. The appellant submissions in rejoinder. The appellant, largely in substance, reiterated his submission in chief, which, in the interest of brevity and unnecessary repetition, we shall not restate here.
Yes.
Thank you, Mr. President. We shall continue with the determination of the court on the appeal and the cross appeal. We have considered the submissions of the parties and the authorities relied on, for which we are grateful. The issue here, as we see it, is when does time attach in this dispute for purposes of Article 32 of the treaty. We shall recall the provisions of Article 32, which provide, and we quote, the proceedings provided for in this article shall be instituted within 2 months of the enactment, publication, directive, decision, or action complained of, or in the absence thereof, of the day in which it came to the knowledge of the complainant, as the case may be. End of quote. This court has on a number of occasions addressed itself to the interpretation of this article. Indeed, a determination of computation of time for purposes of establishing a cause of action is very important because it goes to jurisdiction. The period of 2 months may be measured from the time of the impugned 1, enactment, 2, publication, 3, directive, 4, decision or action, or in the alternative, 5, the day on which it came to the knowledge of the complainant. It should be noted that the reference to decision or action under the above section is drafted in the alternative, and that is an important distinction in this appeal. In the Omar Awadi decision, supra, this court held that when the computation is about an action, then the computation must be from the date the action started, not ended. So an impugned action may comprise a series of events, but for purposes of time, time is computed from when the events started, and the subsequent events therefrom will be judged from that start time or date. Even when it comes to enactments of legislation, one has to take into account a series of events in the legislative process before determining the date when the enactment came into force. This analysis came up in the matter of Media Council of Tanzania versus the Attorney General of the Republic of Tanzania, reference number 2 of 2017, where the court found, and we quote, the respondent appeared to have placed undue emphasis on the word enactment in Article 32. The respondent, in its submission, proceeded on the basis that in legislative process, enactment was equated to passing of a bill in Parliament. Reading Article 32 of the treaty, it is clear that the law known as Media Services Act 2016 became law after firstly being passed by the Parliament of the respondent on November 5th, 2016, and secondly being assented to by the President of the said respondent state on November 16, 2016. The passage of the bill by Parliament was only one step towards the making of the law. Prior to the act being assented to by the President, there was no law in respect of which there could be a complaint. Indeed, as regards Article 32 of the EAC Treaty, the focus was on the action complained of. The action complained of against the respondent was the enactment of the Media Services Act, which became law on November 16, 2016, upon assent by the President. The applicants were well within time in terms of Article 32 in filing reference on January 11, 2017. End of quote. We agree with this analysis of the first instance division on the computation of time. And indeed, when this particular reference came on appeal to this division, the time for cause of action was not listed as a ground of appeal. In this matter, when it comes to when the time should have been computed, the respondent and the intervener wrote for the date of a meeting when the respondent was notified of the decision to take over the ATC more, being the 29th July 2013, evidenced by minutes of a meeting on record, while the respondent, on the other hand, wrote for the actual date of the takeover of the UTC more, evidenced by a letter of the 2nd October 2013. The appellant is also contesting the addition of the actions of the RRA into the second amended reference because those actions, in their view, are separate and after the time of the takeover of the UTC more, and therefore have nothing to do with the original reference. The trial court, in making its findings and decision, held as follows, and we quote from them. We carefully considered the second amended reference. It's abundantly clear that the management of Mr. Rujigiro's shares is not in issue therein. What is in issue is the alleged takeover of the UTC more by the Commission and its subsequent sale by RRA while in the Commission's hands. Those are the matters complained of by the applicant. Indeed, Article 31 does not restrict cause of action to decisions, but extends to actions as well. Therefore, the contention that the 29th of July decision was the only decision taken in relation to the applicant's property would appear to be misplaced. Suffice it to note at this stage that it is to the second amended reference that the recourse would be had to determine the cause of action for purposes of computation of time. End of quote. It would appear to us that the trial court cannot be faulted in its findings. We say so because the takeover of the mall involved a series of events and processes which included meetings like that of the 29th of July 2013. The action of the takeover of the mall has been placed by the respondent to be the 2nd October 2013, when tenants by letter ordered to pay rent to the Commission's bank and not to the management of the respondent. This date of the 2nd October 2013, to our mind, was the date of actualization, because before that date, even though the discussions of the takeover had taken place, the takeover had not been actualized. We say so because from the evidence it is clear that prior to the 2nd October 2013, tenants, regardless of the discussions taking place at the time and earlier, continued to pay their rent to the respondent company. The respondent was therefore within their rights to compute time from the 2nd October 2013 as the time when they lost control of the ATC mall. We answer this issue in the negative. Issue number 3, whether the trial court erred in law in holding that Mr. Rujigiro's Travet, who sued on behalf of the respondent, had locus standi to institute the suit. Appellant's submissions. It is the contention of the appellant that Mr. Trebet Rujigiro lacked the requisite authority to cause the respondent to initiate proceedings in this court, either personally or by attorney. Counsel for the appellant argued at page 45 of his submission that whereas the trial court found that the appellant had mixed up the issues of locus standi with Mr. Trebet Rujigiro's right to initiate proceedings, the appellant's intended arguments at all times was that Mr. Trebet Rujigiro had no authority to initiate proceedings on behalf of the respondent at the EACJ. Counsel further argued that although Mr. Trebet Rujigiro testified that his authority to instruct lawyers for the respondent company was based on an extraordinary general meeting of the respondent company held on the 3rd October 2013, for which there are minutes, the said minutes do not name Mr. Tribet Ruggiero as a specific person represent the company or commence legal action at the EACG or instruct lawyers. Counsel submitted that there was no evidence that the resolution from the said meeting of the 3rd October 2013 was ever filed at the office of the Registry of Companies in Rwanda. He concluded that all the above showed that Mr. Tribet Ruggiero was not authorized to initiate proceedings at the EACG, and so the matter was improperly before the court. The submissions of the interveners. The interveners supported the arguments of the appellant on this issue. Counsel pointed out that Article 27 of the treaty, together with Article 32 of the treaty, in the context of Article 15 of the Protocol on the Establishment of the East African Community Common Market, hereinafter referred to as the Common Market Protocol, excludes land and property issues from regional policy and legal frameworks to be handled by the East African Court. Counsel argued that this means that such issues have to be governed and adjudicated over by national laws and national courts, which have jurisdiction over such matters, except where the state actions in such cases are against the rule of law. Counsel in this regard referred us to the decision of Katabazi and 21 others with the Attorney General of Uganda and the Secretary General of the EAC, reference number 1 of 2007. Counsel argued that the trial court therefore erred in law when they found, and we quote, "We are constrained to respectfully state here that domestic law of a partner state would be irrelevant to the determination of local standard in the court. The court would have supremacy on that issue. Thus, Article 8.4 of the treaty gives preeminence to community laws in the implementation of the treaty. It reads, community organs, institutions, and laws shall take precedence over similar national ones on matters pertaining to the implementation of the treaty." End of quote. Counsel further argued it was wrong for the trial court to find that a person with a certificate of registration could initiate a court case on behalf of a company. Counsel for the interveners submitted that the interveners never consented as shareholders or board members of the respondent company to file a claim against the government of Rwanda at the EACG. Counsel further argued that the interveners tried to explain this in their submissions together with evidence by way of affidavits, but the trial court did not give any consideration to them showing bias against the respondents. Counsel further submitted that Article 223 of Law Number 07/2009 of the 27th April 2009 of Rwanda relating to companies requires a shareholder to undertake a derivative action in order to file a claim or sue on behalf of a company. For the avoidance of doubt, the law provides, and we quote, a company, a member of the board of the directors, a shareholder may request the court to file a claim on behalf of the company or its subsidiary. End of quote. Counsel submitted that the above provision of Rwandan law has not been complied with in initiating the reference before the trial court. Counsel argued that a company incorporated under the laws of Rwanda has a separate legal personality from its owners. The trial court therefore erred by assuming that Mr. Ruggiero can file a claim on behalf of the respondent without presenting a notarized resolution to the court indicating that the respondent company had agreed to file the reference at the trial court. Counsel argued that, in so doing, the company completely ignored the minority shareholders' rights and position, which was that they were not interested in suing the government of Rwanda. This, she submitted, was not fair because it was the majority shareholders versus the minority shareholders trying to convince the court that the reference was authorized by the company. Respondent submission. Counsel for the respondent opposed the issue. He argued that the respondent, the applicant at the trial court, was the company Union Trade Center and not Mr. Trebet Rugigiro. It was therefore the respondent company which had locus standi, not Mr. Trebet Rugigiro, in this matter, and that is what the trial court labored to explain in its judgment. Counsel submitted that the trial court at page 49 of the judgment emphasized that representation has nothing to do with locus standi to institute the reference, and the respondent at the time properly appeared before the court through its advocates, who in turn fulfilled what was expected of them under Rule 19.7 of the rules of this court. The submissions of the appellant submissions in rejoinder. The appellant largely in substance reiterated his submissions in chief, which in the interest of brevity, we shall not restate. Determination of the court. We have considered the submissions of the party on this issue, and the authorities relied on, for which we are grateful. The argument around this issue is multifaceted. However, we shall begin by recalling the decision of this court in Simon Peter Cheng Supra, where it was held that, and we quote, litigants should bear in mind that this court is not tasked to undertake a rehearing de novo of questions of fact and law examined by the first instance division. The right to appeal to the appellate division is restricted to the extent that the appeal falls within the scope of Article 35A, end of quote. Counsel for the appellant tried to restate what their intended argument at the trial court was. Submitted that the appellant's intended argument at all times was that Mr. Trebet Rugigiro had no authority to initiate proceedings on behalf of the respondent at the ESCJ. This appellate court does not, under Article 35A and Rule 86 of the rules of this court, deal with what intended arguments would have been at the trial court. This is also the line of argument. This is the line of argument also taken up by the interveners. However, since the trial court found there was a mix-up of the legal arguments and concepts, we are forced to bring clarity to these matters. We find that the real question must be whether the respondent company had legal standing to bring the reference. Article 31 of the treaty provides, and we quote, subject to the provisions of Article 27 of this treaty, any person who is resident in a partner state may refer for determination by the court the legality of any act, regulation, directive, decision, or action of a partner state or an institution of the community on grounds that such act, regulation, directive, decision, or action is unlawful or is an infringement of the provisions of the treaty. We shall begin with the legal arguments of the interveners, which also captured the appellant submission, but in greater detail. Counsel for the intervener has referred us to the exception in Article 27(1) of the treaty, which provides, and we quote, provided that the court's jurisdiction to interpret under this paragraph shall not include the application of any such interpretation to the jurisdiction conferred by the treaty on organs of a partner state, end of quote. Counsel argued that the above provision, when read with Article 15 of the Common Market Protocol, excludes land and property issues from the regional policy and legal framework of the East African Court of Justice. This means that the court lacks jurisdiction to adjudicate land and property matters. With the greatest of respect, this argument is totally misplaced. This dispute in this matter is one of a company, that is the respondent, and not land. This distinction is very clear. Indeed, the counsel for the interveners later goes on to argue that the respondents, and in particular that Mr. Terebet Ruggiero did not comply with Article 223 of Law Number 07/2009 of the 27th April 2009 of Rwanda relating to companies, not land, which requires a shareholder to undertake a derivative action in order to file a claim to sue on behalf of a company. Again, we find this argument misplaced because the respondent was not launching its reference in the courts of Rwanda, but rather at the EACJ, whose operative provision is Article 31, which article is not in pari materia with the Rwandan law. So, to launch a reference at the EACJ, all the party needs to do is to comply with the treaty provisions and not domestic law. As to the intervener's submissions that the company and the shareholders have different legal personalities, and the trial court therefore completely ignored the minority shareholders' position, which was that they had no interest in the reference. We find this argument very puzzling. In this matter, it is not in dispute that the respondent company comprises 5 shareholders. Mr. Terebet Ruggiero has 1,933 shares, which is about 97.3%. The rest of the shareholders, including interveners, Mr. Theonest Mutabuka had 41 shares, Tracy Ingofero, 3 shares, and Succession Mukuza Desire, 3 shares. And Succession Nkurunziza Gerald, 20 shares. Obviously, Mr. Terebet Ruggiero was the majority shareholder by far, and even though the majority shareholders together voted against going to court, this will not have changed any resolution of the company to the contrary, as he had the majority vote. The majority vote would then reflect the will of the company. It was a contrary. If there was a contrary resolution of the respondent company, then the onus was on the appellant, supported by the interveners, to produce it in the court, but they did not. Counsel for the interveners further argued at paragraph 27 of their submission that considering all the challenges that were associated with being shareholders in the respondent company with Mr. Terebet Ruggiero, the interveners decided to file for liquidation and dissolution of the company, especially given the fact that their investment was dormant and making losses. We have no evidence on record that the respondents' internal governance documents showed that the minority shareholders could legally veto a majority vote, which in any case would have been very unusual in company law and corporate governance. In any event, there are minutes of an extraordinary general meeting of the 3rd October 2013 of the respondent on record where it was resolved, and this is captured in the judgment of the trial court at page 549 of the record of appeal, that, and we quote, the shareholders decided that they do not exclude the option of having recourse to the courts of law, if possible, for purposes of safeguarding the interests of the company, end of quote. The appellant and the interveners who lack authority have not adduced any evidence from the company to the contrary. In any event, what do the rules of this court say about a company's authorization? Rule 25 of the rules of this court provides, and we quote, a corporation or a company may appear by its directors, manager, or company secretary who is appointed by a resolution under the seal of the corporation or company, or may be represented by an advocate, end of quote. The above rule gives options to corporations or companies to appear in the court, namely by 1, a director, manager, or company secretary who is appointed by resolution under the seal of the corporation or company, or 2, an advocate. In one of the few cases involving the position of a company suing at international law, the International Court of Justice in the Barcelona traction light and power case, which was Belgium versus Spain, International Court of Justice reports 1970 held as follows, and we quote, "It cannot, however, be contended that the corporate entity of a company has ceased to exist or it has lost its capacity to take corporate action. It has not become incapable in law of defending its own rights and interests of the shareholders. In particular, a precarious financial situation cannot be equated with the demise of the corporate entity, which is a hypothesis under consideration. The company's status in law is alone relevant and not its economic condition, nor its possibility of being practically defunct, a description on which argument has been based, but which lacks all legal precision. Only in the event of the legal demise of a company are the shareholders deprived of the possibility of a remedy available through the company. It is only if they become deprived of all such possibility that an independent right of action for them and their governance can arise. In the present case, Barcelona Traction is in receivership in the country of incorporation. Far from implying the demise of the entity or its rights, this much rather denotes that the rights are preserved for so long as there is no liquidation, for so long as no liquidation has ensued. Though in receivership, the company continues to exist. End of quote. It will therefore appear to us that under customary international law, for a company to sue and appear in an international court such as this one, the company's legal status in law alone is relevant, and this would still be the situation when a company is said to be under receivership. The trial court, that is at pages 547 to 578, held as follows, and we quote, Article 31 does not hinge locus standi to institute a reference on residence. I'll read that again. Article 31 does hinge locus standi to institute a reference on residence or domicile within any partner state. Without a doubt, as deduced from its certificate of registration, the applicant company is indeed domiciled within the respondent state. No evidence to the contrary was adduced by either party. Neither was it proposed or even proven that it was not so domiciled. The certificate of registration would therefore be conclusive on the subject. To the extent that it depicts the applicant as a company domiciled in the respondent company, it does denote the applicant's locus standi in the present case. We are constrained to respectfully state here that domestic law of a partner state would be irrelevant to the determination of locus standi in this court. The treaty would have supremacy on this issue. End of quote. We are unable to fault the finding of the trial court, and for the following reasons. First, when the reference first came up, it is common ground that the respondent was in existence and therefore could initiate his own case under the treaty and rules of the court. The respondent also meets the test under Rule 25 of appearing by advocate. Furthermore, even though under Article 25 there is no requirement for advocates to show evidence of instructions or other resolution, we are fortified by the fact that there is a company resolution of the 3rd October 2013 showing that the company was inclined to go to court. Even though the interveners contest this, the onus is on them to prove the contrary. However, in our views, the interveners have failed to do so. They have not adduced evidence of minutes from the respondent company to the contrary, In any event, we again fortified under company law that by the level of shareholding the interveners possessed, they would have not had the ability to stop the respondent company as a separate legal entity from them from pursuing legal action at the ESCJ to protect itself from the actions of the appellant. A finding to the contrary would offend all principles of good corporate governance and company law. Indeed, it is almost incredible to believe that minority shareholders could have the voting power to enable them to file a company's liquidation. A company is a very important vehicle for trade and investment, and such a legal situation will seriously discourage investment through companies in our region. From the above findings, it is clear to us that it is not Mr. Trebet Ruggiero per se as a shareholder who sued on behalf of the respondent company. Respondent company as an entity in existence and separate from its shareholders filed the matter at the ESCJ on its own behalf and indeed had local standing under the treaty to do so. Further find that in all their submissions, the appellant and the interveners have failed to establish bias by the trial court in its proceedings and judgment. Bias by the trial court needs to be actively established by the party that alleges it, and not to be founded on disagreement with the findings of the court, which in any event can be appealed. Accordingly, we answer issue number 3 in the negative. Issue number 4. Whether the trial court erred in holding that the appellant's action of taking over the respondent's UTC more and its subsequent auctioning was inconsistent with Articles 53G, 6D, 71A, and 81A, and B and C of the Treaty for the Establishment of the East African Community. Appellant submissions. Counsel for the appellant argued that the trial court lacked jurisdiction under Articles 27 and 30 of the treaty to interrogate the applicant's taking over of the ATC mall and its subsequent auctioning, but the trial court ignored this at the scheduling conference. Counsel argued that the second reference did not cure the need to interrogate whether the trial court had jurisdiction, especially on issues of time frame. He submitted that if the trial court had done so, then the proposition as to jurisdiction would totally have disposed of the reference. He prayed that this court finds that the trial court had no jurisdiction to make the awards and the orders and awards it did in favor of the respondent. Counsel referred us to our decision in the Attorney General of Tanzania versus Anthony Kalescom, Appeal number 2 of 2015, for the proposition of the law that if a court lacks jurisdiction, then it will have no cause for examining substantive issues, however important or grave they may be. Submissions of the intervener. The intervener did not address this issue. The respondent's submissions. Counsel for the respondent opposed the issue and submitted that the trial court did not commit any errors of law or procedural irregularity. Counsel argued that the sum total of the appellant's illegal actions towards the respondent company violated the treaty. He submitted that the trial court properly summarized the evidence presented for it at paragraphs 110, 111, 112, 113, 114, 121, and 122 of the judgment. He argued that the trial court had found that the appellant had failed to controvert the evidence adduced on record, which therefore stood unrebutted. Appellant's submissions in rejoinder. Counsel for the appellant reiterated his earlier submissions that the trial court lacked jurisdiction to interrogate this issue. In the alternative, counsel submitted that the respondent had failed to adduce cogent evidence to prove the impugned actions or decisions of the appellant. He argued that a national corporation being dissatisfied with the actions of a partner state cannot of itself amount to a violation of the treaty, and especially Article 5 thereof. Furthermore, Council submitted that there was no violation of Article 6D of the treaty, because evidence showed that quasi-judicial administrative steps were taken against the respondent, and that provision was made for the respondent to be heard during the process. Council argued that Rwandan law and judicial processes had been upheld, but the respondent was just dissatisfied. Council further submitted that the appellant was an ardent supporter of the EAC community program and ensured that a liberalized and free market economy operated in Rwanda and the EAC community. Determination of the court. We have considered the submissions of the parties on this issue and the authorities relied on, for which we are grateful. We find that the appellant has largely reiterated these arguments against the trial court being seized with jurisdiction that we have already addressed under issues number 1 and 2 hearing. We have already found against the appellant in this regard and found that the trial court had jurisdiction, and therefore it serves no purpose for us to address this matter of jurisdiction again. Indeed, the argument of lack of jurisdiction appeared to be the main thrust of the appellant's defense at the trial court, and therefore the appellant unfortunately ended up not fully addressing the substance of the allegations against it. At the scheduling conference, there were attempts by the appellant and the interveners to provide fresh evidence on appeal, which is not possible under Article 35A of the treaty. Since the appellate division cannot take appeals on points of fact, indeed, the interveners in particular took exception to the affidavits accompanying their statements of intervention being struck out by the trial court. Article 40 of the treaty provides for intervention and provides that, and we quote, a partner state, Secretary General, a resident of a partner state, who is not a party to a case before the court may, with leave of court, intervene in that case, but the submissions of the intervening party shall be limited to evidence supporting or opposing the argument of a party to that case. Furthermore, when a court allows an application for intervention, Rule 59 of the rules of this court then further provides that the intervener shall accept the case as it is at the time of intervention. The meanings of these provisions is that the intervener comes by way of submissions, which shall be limited to the analysis of the evidence supporting or opposing the arguments of a party to a case. The intervener thus takes the case, its evidence on record, as he or she finds it at the time of intervention, but does not by reason of admission become a party who brings his or her own independent evidence to the case. All the intervener does in practical terms, therefore, is to file a statement of intervention supporting or opposing the evidence on record of one of the parties to a reference. The approach of the intervener, therefore, in this matter was erroneous, and the trial court was correct to strike out their evidence. The above notwithstanding, the respondent has directed us to the findings of the trial court on the substance of the issue, which we find are pertinent, and we reproduce them below for ease of reference, and we quote, in the instant case, the UTC mall did not amount to property that had been abandoned following the 1994 genocide, so as to amount to abandoned property within the ambit of Law 28 of 2014. No evidence to that effect was adduced at trial. On the contrary, it was the respondent's contention that the commission assumed management of Mr. Rugigero's shares because he was out of the country. However, our earlier decision on the shares notwithstanding, We find that Article 10 of Law number 28 of 2014 points to the contrary. That provision states most categorically that the fact of being abroad will not entitle him of his property or the right to manage or otherwise deal with it. The only exception being if he was being or had been prosecuted for genocide. There is no such evidence on record. Perhaps more importantly, the Commission's intervention in the management of the UTC Mall with its October 2nd letter was without legal basis. If, as advanced by Learned Counsel for the applicant, had its own management, there was no clear reason for the Commission to illegally redirect the tenant's rent elsewhere. That conduct in itself would amount to a violation of the applicant company's rights to use and enjoy an enjoyment of its property. That provision has universal application within partner states, placing as much obligation upon regional governments as their citizens to abide by national policies and laws in land and property management. In the instant case where the Commission applied an inapplicable law to dispossess the applicant of its right to possession, operation, and use of the UTC Mall, it acted illegally the respondent state's own municipal law, and thus occasioned an illegality within the precincts of Article 31 of the treaty. The Commission's conduct does, to that extent, flout the rule of law principle espoused in Article 6D and 7.2 of the treaty. In addition, insofar as it contravenes the property rights that underpin Article 15.1 of the Common Market Protocol, said conduct amounts to measures likely to jeopardize the realization of the East African Common Market as set out in Articles 8.1 and 8.1c of the treaty. The obligations highlighted above by virtue of the instruments from which they derive international obligations. Consequently, not only is the Commission's wrongful conduct attributable to the respondent state under Article 2A of the ILC Articles on State Responsibility, its breach of international obligations engenders the respondent's international responsibility thereof under Article 2 of the same legal instrument. In the instant case, as demonstrated above, the applicant has so sufficiently demonstrated RR's inconsistency with the treaty as to shift the evidential burden on the respondent to demonstrate its consistency. However, the respondent's evidence falls short on the requisite rebuttal of the applicant's contestations. In fact, aspects of the respondent's evidence do in fact lend credence to and corroborate the applicant's allegations. We are satisfied, therefore, that by circumventing the express provisions of Article 27 of Law number 25 of 2015, RRA's tax audit process contravened the rule of law principle in Article 6D and 7.2 of the treaty. Furthermore, having omitted to declare the monies retrieved from UTC's garnished accounts so as to justify its seizure and auction of the mall, RRA's conduct was riddled with lack of transparency, and that contravenes Articles 6D and 7.2 of the treaty. The said entity did similarly offend the principle of accountability in the treaty provisions by not remitting the applicant's monies outstanding from the mall sale. RRA's impugned conduct is attributable to the respondent state under Article 2 of the ILC Articles on State Responsibility. We agree with the above findings of the trial court, and for the following reasons. First, the appellant did not rebut the factual allegations of the takeover an eventual auction of the ATC mall. So that evidence was uncontroverted. Both of these actions together ultimately led to the sale of the ATC mall. Secondly, and perhaps most importantly, there was throughout the trial a perpetual mix-up by the appellant between the actions of the respondent company and one Trebet Ugiro, who is the majority shareholder. This, in our view, was a conceptual error because the two are legally different. Even though, as counsel for the appellant put it during the hearing, that it was general knowledge that Mr. Trebet Rukijero had fled Rwanda on apprehension of criminal charges being preferred against him, and that he was unlikely to return. The respondent company, on the other hand, did not legally leave Rwanda, but rather continued to remain active with its management in place. A proposition that because of the alleged run-in with the law by Mr. Trebet Rugidero, and that is for him as an individual, that is for him to answer as an individual, and subsequently fleeing the country, that means that his shares or his company had been abandoned in Rwanda and cannot therefore operate, would send a very dangerous negative signal for investment in that country and the region at large. A company has its own life through its organs like shareholders, board of directors, and then management. Even the allegation that Mr. Trebet Rukijero, as a shareholder, had committed fraud on the respondent company would not have to be placed on the I'll read that again. Even the allegation that Mr. Trebet Rukijero, as a shareholder, had committed a fraud on the respondent company would have to be placed on the shareholder personally to account without creating a threat to the existence of the company itself. It is the case for the interveners that, with respect to the said fraud, they had opened a criminal case against Mr. Trebet Rugijero personally. This, in our view, was the right thing to do, rather than seek the liquidation of a company that, from all evidence, was still a going concern. Accordingly, taking our findings together, we answer the issue in the negative. The cross appeal. Counsel for the respondent, counter claimant hearing still referred to as the respondent, has addressed issues number 5 and 6 together. We shall equally resolve them together. So issue number 5 read whether the trial court erred in law when it omitted to make further orders beyond requiring the appellant to furnish the respondent with accountability for rental and sale proceeds realized from the UTC mall between the 1st October 2013 and the 27th September 2017 by the appellant. And issue number 6, whether the trial court erred in law when it omitted to make an order for restitution of the mall, or in the alternative, full compensation for the value of the mall on finding that it was illegally seized and sold by the appellant. The respondent's submissions. Counsel for the respondent submitted that the court has a duty to ensure adherence to the treaty, and in appropriate circumstances where breach has been proved, to award effective redress. In this regard, we were referred to the decision of this court in Honorable Dr. Margaret Ziwa versus the Secretary General of the East African Community, appeal number 2 of 2017. Counsel argued that whereas the court found that the appellant had violated the treaty, it failed to give effective remedies and orders of reparations and redress to redress the wrong done. He submitted that the trial court only issued a directive to the appellant to furnish the respondent company with accountability for rental and sale proceeds. realized from the sale of UTC Mall between the 1st of October 2013 and 27th September 2017, without any further orders to remit the rental corrections and sale proceeds to the respondent company. The trial court further awarded damages in the sum of $500,000 and interest at 6% per annum till payment in full, which was insufficient and ineffective compensation given that the ATC Mall had been sold by the RRA for the sum of Rwanda franc 6,877,150. Counsel submitted that the evidence adduced had shown that the respondent company earned a monthly rent of $120,000 at the time of takeover, which translated to earnings of $1,440,000 USDs yearly, and a total of $5,760,000 for the 4 years the mall was in the hands of the commission. Counsel argued that the trial court ought to have granted the respondent company USDs $5,760,000 for the illegal takeover, seizure, and auction of the ATC Mall. He argued that the compensation granted fell below the accepted international standard as held by the Permanent Court of International Justice in the matter of the factory at Chezo, the judgment number 13 of the 13th September 1928, Series A, number 17, at page 47, where the court found, and we quote, "Essential principle contained in the actual notion of an illegal act is that reparations must, as far as possible, wipe out all the consequences of the illegal act and re-establish the situation which would, in all probability, have existed if that action had not been committed. This can be accomplished through restitution in kind, or if that is not possible, through just compensation, meaning payment of a sum corresponding to the value of which restitution in kind would bear." End quote. Counsel further submitted that in the matter of Solar Tiles Inc. and the government of the Islamic Republic of Iran, IUSCT case number 37, which involved the expropriation of companies' assets, the tribunal there determined, among other factors, that the market value of Messrs. Solar Tiles Inc. at the time of expropriation and factored in issues like lack of access to detailed documentation, and awarded $207,782 for lost profits, for loss of assets, profits, and goodwill. The appellant's submissions in reply. The appellant opposed the cross appeal. Counsel for the appellant submitted that the remedies prayed for by the respondent are neither pleaded nor backed by sufficient and cogent evidence. Counsel argued that the evidence that UTC Mall earned $120,000 per month, and that the UTC Mall had no debts, was unreliable. This is because there was evidence that the UTC Mall owed Rwanda francs $1,300,000 to the Bank of Kigali. That is $2,900,000 $2,900,000 to Nick International, and a lot of money to RRA. Submissions of the interveners. The interveners agreed with the submissions of the appellant. Counsel for the interveners further wondered to whom compensation should be made, since the interveners, as majority shareholders, were happy with the takeover of the UTC Mall. Since Mr. Tribet Rujigiro, the majority shareholder and managing director, had abandoned the management of UTC Mall to the detriment of the ATC, to the detriment of the minority shareholders. Secondly, counsel for the interveners submitted that the minority shareholders had filed a case for liquidation of the respondent company at the Commercial Court of Rwanda, which court appointed a liquidator pursuant to court ruling number 01304 of 2020, stroke PC. The respondents' submissions in rejoinder. The respondents did not file a rejoinder.
The determination of the court. We have considered the submission of the parties on this issue and the authorities relied on, for which we are grateful. This issue relates to the remedies that the trial court awarded. Before we address the issue of what the court awarded, it is necessary for us to clarify on a few matters. We wish to recall the decision of this court in Honorable Dr. Margaret Ziwa Supra on the issue of state responsibility for international wrongs, where the court found that whereas the treaty does not specifically provide for remedies, still the applicable principle in this regard are, and we quote, those expressed by the International Law Commission, ILC, in its draft articles on the responsibility of international organizations, which commentaries 2011. The draft articles detail the international responsibility of international organizations in Article 3, 4, and 6, which are in Part 2, and the legal consequences for breach thereof in Article 30, 31, 33, 34, 35, and 36, which are in Part 3. End of quote. This court further held in Honorable Dr. Margaret Ziwa Supra that where the court found a breach, then we quote, the legal consequences of such breach would, if the complainant were a state or another international organization, be cessation and non-repetition, Article 30, and or reparation, Article 31. Article 34 makes it clear that reparation may take the form of restitution, compensation, and satisfaction, either singly or in combination. End of quote. In this matter, the appropriate remedy would be that found in Article 31 of the ILC, which provides Article 31, reparation. 1. The responsible state is under an obligation to make full reparation for the injury caused by the internationally wrongful act. 2. Injury includes any damage, whether material or moral, caused by the internationally wrongful act of a state. The obligation under Article 31 of the ILC, therefore, is to make full reparation. The leading case in this regard, which also reflects the position of customary international law, has already been cited to us by the respondent, and that is the factory and the Charles Supra. In this case, full reparation was understood to mean, and we quote, that reparation must, as far as possible, wipe out all the consequences of the illegal act and re-establish the situation which would, in all probability, have existed if that act had not been committed. End of quote. In this matter, reparation would go to the respondent company. There is no ambiguity here, as counsel for the interveners would have it. The UTC Mall may have been sold, but the company still exists until full and final liquidation, after which the benefit would be for the stakeholders. How then would full reparations be assessed? The onus would be on the respondent to adduce the necessary evidence of the injury caused by the internationally wrongful act, whether it be material or moral. It has been argued for the appellant and the interveners that the respondent did not pray for these remedies. From the record, what the trial court found is that the respondent did not pray for or establish what they refer to as special damages. What Article 31 of the IRC, on the other hand, dictates is ipso facto full reparations, and so the difference of pleading at a domestic and international law should not be lost. Article 31(2) IRC gives guidance. Full reparations, which includes any damage, whether material or moral, caused by internationally wrongful act of a state. However, where there is material loss, we state that evidence of it should be adduced. Paragraph F of the second amended reference avers. Relief sought, we therefore, the relief sought. We therefore, where therefore the claimant prays this honorable court for 1, declarations that the actions of the respondent, now the appellant, overtaking over the claimant's property and consequently selling it off are illegal and contravene Articles 5(3)(g), 6(d), 7(1)(a) and 2, and 8(1)(a) and C of the treaty. 2, an order directing the respondent to account for all proceeds from the claimants more from the 1st October 2013 to date. 3, an order directing the respondent to return the claimant the said more and all properties therein. 4, general damage and costs of this reference. And finally, that this honorable court be pleased to make such other orders as may be just and necessary in the circumstances. We find these pleadings, though drafted as if in the domestic courts, sufficient to constitute a prayer for reparations for injury as understood under the IRC. Some of the injury, however, would require proof. In this matter, the prayer under F3 under the head reliefs is not realistic, as the UTC mall was sold and has new owners. It follows under international law that where restitution is not possible, then compensation should be made. However, in order to obtain full reparations, it would also have been necessary during the course of the hearing for an order for discovery to have been made so that those figures could have been adduced in evidence and factored into the judgment, which was not done. In this matter, the trial court relied on its own decision in Grand Lac Supplier SARL versus the Attorney General of the Republic of Burundi, reference number 10 of 2013, and held in paragraph 133 as follows, and we quote: the foregoing injury is virtually identical with that suffered by the applicant, now the respondent, in this reference. In the instant case, it was Mr. Rujugiro's uncontroverted evidence that UTC Mall was fetching a monthly rental of USD 120,000 as at the date of its takeover. This would translate into a yearly earning of USD 1,440,000 USD over the 4-year period it was in Commission's hand. Total income of USD 5,760,300. Although these monies were not proven for purposes of special damages, we would apply the pro rata rate in the Grand Lac Supplier case as the basis for an award of general damages. After discounting monies expended in the maintenance of the mall, we consider USD 500,000 a fair award of general damage. End of a court. This was from the first division. We find that the reliance by the trial court on the grant supplier case Supra of awarding 500,000 USD is a fair award of general damage does not meet the master of the later, Honorable Dr. Margaret Ziwa appeal Supra of full reparations as guided by the ILC. In any event, if the trial court awarded general damages or moral damages as they are better known under international law, as they did, it did not make sense to have reduced the said award given by what was termed the maintenance of the mall, which figure was also not adduced in evidence. In this determination, it is not possible to know what was the trial court's starting point for the award of damages and then where they got the figure for maintenance that was deducted. Given the age of this dispute and the challenges of transparency in the management of the funds as found by the trial court in their judgment at paragraph 118, and with a view of bringing an end to litigation, we, in the interest of justice, award a block figure where aware that full reparations may not be achieved. We accordingly find that for the appellant violating Article 5.3G, 6D, 7.1A and 2, and 8.1A and C of the treaty, we award an enhanced figure of USD 1 million against the appellant in favor of the respondent. We further award interest at 6% per annum from the date of the judgment of the trial court until payment in full. We, however, drop the award of making an account of the proceedings because of obvious difficulties that will come with enforcing that order without an earlier discovery of the figure during the trial. As to costs, we grant costs to the respondent here in the main appeal, in the cross appeal, and also in the trial court. And then the final orders. The award at the trial court is hereby replaced and substituted as follows. 1. A declaration is hereby issued that the appellant's actions of taking over the UTC mall and subsequently selling it off are illegal and contravenes Article 5.3G, 6D, 7.1A and 2, 8.1A and C of the treaty. 2. For the appellant's violation of Articles 5.3G, 6D, 7.1A, and 2 and 8.1A and C of the treaty, the award granted by the trial court is enhanced from 500,000 USD to the figure of 1 million USD against the appellant in favor of the respondent. Costs are awarded to the respondent here in the main appeal and the cross appeal and also in the trial court. We so ordered. Dated at Arusha this 30th day of May of August 2022. This is the judgment of the court.
Most obliged, my lords.
Most obliged.
Most obliged, my lord.
Most obliged, my lords.
So this makes the end of this sitting.